This video is a discussion of parental alienation syndrome. On August 15, 2011, CPS Social Worker 3 said while giving the reason for a founded CPS finding of emotional abuse, "In 11 years of investigating, I've never seen such strong evidence of parental alienation as I have in this case." To begin the discussion, we'll start with T. Burton's brief. T. Burton asked, "What is parental alienation syndrome?" PAS is the creation of one man, Richard Gardner, a psychiatrist who discovered the so-called syndrome in approximately 1985. Although he has been presented as a professor of child psychiatry at Columbia University, Gardner committed suicide in 2003, actually worked as a clinical professor of psychology in Columbia's Division of Child and Adolescent Psychiatry, which is an unpaid volunteer position. Gardner's PAS theory was developed solely through personal observations of his patients in private practice. Gardner introduced the theory to explain what he considered to be an epidemic of false accusations of child sexual abuse. Gardner actually avoided peer review by publishing his books through his own private publishing company. PAS is merely a theory, not an accepted psychological syndrome or a diagnosis. It has not been recognized by the American Psychiatric Association or any other respected medical or professional association. PAS is not included in the 4th edition of the Diagnostic and Statistical Manual of Mental Disorders, otherwise known as the DSM-4, or any earlier version of that respected diagnostic manual. Child psychologists and child psychiatrists routinely rely on the DSM-4, which includes only those disorders that have been subjected to intensive research and peer review, to diagnose and treat recognized mental disorders. The introduction to the DSM-4 states that utility and credibility of the DSM-4 requires that it focus on its clinical, research, and educational purposes and be supported by an extensive empirical foundation. There are some fathers' rights groups who are mounting a letter-writing campaign to have PAS included in DSM-5, which is ridiculous because the DSM is based on research, clinical test, and professional judgment, not letters of opinion. Dr. Kaplan Today offers more information about this on his PAS is a Scam website. The website looks like this. Dr. Kaplan Today writes, "Update for the article about parental alienation syndrome. DSM-5 head writes that PAS will not go in the manual." The update looks like this. Dr. Kaplan Today writes, "On June 9, 2011, I was one of 3 recipients of a letter from DSM-5 Task Force Chair David Kupfer and DSM-5 Task Force Public Representatives James McNulty." Dr. Kaplan Today writes, "The news in their letter is that because of the high evidence threshold required, the task force is not currently recommending the inclusion of parental alienation syndrome." When PAS is used. From T. Burton's brief, PAS has been asserted in cases such as his, involving other types of abuse in situations in which a child refuses to visit a parent for other reasons. You can see Carol S. Bruch, Parental Alienation Syndrome in Alienated Children, Getting It Wrong in Child Custody Cases, which appeared in the Family Legal Quarterly in 2001. Gardner's theory rests on the premise that the vast majority of abuse allegations in custody cases are false and the result of one parent's alienation of the child from the other parent. Specifically, Gardner theorizes that the child not only is systematically brainwashed by the alienating parent, usually the mother, but that the child is also subconsciously programmed by that parent to hate the other parent, who is usually the father. Justice Chisholm of the Indiana Court of Appeals has stated, "This gender-based generalization is ludicrous and an affront to all reasonable women and men. It is unacceptable." Likening PAS to pop psychology or cult theories like Peter Pan syndrome or the Cinderella complex, Justice Chisholm went on to describe PAS as a disturbing, inflammatory, unscientific, and unsubstantiated theory which has no place in our courtrooms. Now, according to Gardner, this programming results in false accusations by the child of abuse. PAS is founded upon circular logic, which also makes it inherently unreliable as a scientific diagnostic tool. PAS is offered to prove that abuse did not occur yet it assumes the truth of what it seeks to prove, that the child's allegations of abuse are false. Gardner contends that the vast majority of abuse allegations that arise in child custody disputes are false, and one of his strongest criteria for proving the falsity of an allegation is the fact that it was first raised in a child custody dispute. The child's allegations of abuse are seen as the product of a mental disorder suffered by the child as a result of the supposed alienation, and as the product of a warped perspective, the allegations are discounted and even completely ignored by counsel, courts, and others who subscribe to Gardner's description of parental alienation syndrome. According to T. Burton's brief, it is frankly irresponsible to describe such conduct in terms of a psychological syndrome that supposedly produces a mental defect in a child and automatically renders the child's revelations of abuse incredible. The discredited diagnosis of PAS, or an allegation of parental alienation by social workers, quite apart from its scientific invalidity, inappropriately asks the court to assume that the child's behaviors and attitudes toward the parent who claims to be alienated have no grounding in reality. It also diverts attention away from the behaviors of the abusive parent who may have directly influenced the child's responses. Dr. Kaplan today points out that it is the task of the court to distinguish between situations in which the child is critical of one parent because they have been inappropriately manipulated by the other, taking care not to rely solely on subtle indications, and situations in which the child has his or her own legitimate grounds for criticism or fear of a parent, which will likely be the case when that parent has perpetrated domestic violence. Those grounds do not become less legitimate because the abused parent shares them and seeks to advocate for the child by voicing his or her concern. There's more information about parental alienation syndrome from the Justice for Children website, which looks like this. It is the position of Justice for Children that PAS is junk science. T. Burton's brief points out that PAS is not only junk science, it is dangerous science. Mr. Burton states that reliance on a facile diagnosis of PAS in custody decisions puts abused children at extreme risk of further abuse because PAS encourages courts to discount, even ignore a child's allegations of abuse without proper investigation. Under Gardner's theory, a child's outcries of physical or sexual abuse against one parent are seen merely as the product of alienation by the other parent. Therefore, courts relying on PAS frequently fail to investigate the child's allegations, and they may even reject independent evidence of the abuse, which is exactly what happened in Mr. Burton's client's case. According to Gardner, the children should be completely removed from the alienator's influence, and all contact between the alienating parent and the children should be cut off, and the children should be deprogrammed. According to Gardner, the only way to counteract parental alienation is to place the child in the sole custody of the alleged abuser and severely limit or even totally prohibit contact with the alienating parent. Thus, the child is delivered into the hands of the abuser and cut off from any outside protection and support. It is hard to imagine the confusion and hopelessness experienced by such children. Mr. Burton requested the court to address the scientific validity of PAS, or lack thereof, and conclude that PAS is junk science. He asked the court to hold that PAS evidence should not be admitted because it is not generally accepted in the scientific community, it is inherently unreliable, and it endangers children. Because it has not been accepted or endorsed by any professional organization or association in the fields of psychology or psychiatry, Gardner's PAS theory is inadmissible under either the Frye test or the more recent standard established by the United States Supreme Court. You can see Frye v. U.S. or Darbert v. Merrill Dow Pharmaceuticals. Justice for Children states it this way: PAS cannot pass the challenges for acceptance as scientific or expert in courts of law. These challenges are called Daubert challenges, named after a Supreme Court ruling on what constitutes scientific or expert testimony. Testimony that a party to a custody case suffers from the syndrome should therefore be ruled inadmissible both under the standard established in Daubert and the stricter Frye standard. The National Council of Juvenile and Family Court Judges has a position that PAS is not to be used in court. From the Justice for Children website, the Council of Judges has deemed that the evidence against the existence of PAS is sufficient enough to throw out the concept entirely. Hopefully this will bring some justice to those who have been unlawfully accused of this imaginary and outrageous syndrome. Mr. Burton cites the 2006 position of the National Council of Juvenile and Family Court Judges. It's in the publication Navigating Custody and Visitation Evaluations in Cases with Domestic Violence, a Judge's Guide. The guide includes a section on the admissibility of parental alienation syndrome testimony in custody hearings, which appears on page 19 of the 2006 version. Dr. Kaplan today, on his PAS is a Scam website, gives a word of caution about parental alienation. Dr. Kaplan cites a 2009 resource. The 2009 Judicial Guide to Child Safety in Custody Cases from the National Council of Juvenile and Family Court Judges Family Violence Department, on page 12, a word of caution about parental alienation. Under relevant evidentiary standards, the court should not accept testimony regarding parental alienation syndrome or PAS. The theory positing the existence of PAS has been discredited by the scientific community. In Kumho Tire v. Carmichael, the Supreme Court ruled that even expert testimony based in the soft sciences must meet the standards set in the Daubert case. Daubert, in which the court re-examined the standard it had earlier articulated in the Fry case, requires application of a multi-factor test, including peer review, publication, testability, rate of error, and general acceptance. PAS does not pass this test. Any testimony that a party to a custody case suffers from the syndrome or parental alienation should therefore be ruled inadmissible and stricken from the evaluation report under both the standard established in Daubert and the earlier Fry standard. The National Council of Judges has deemed that the evidence against the existence of PAS is sufficient enough to throw out the concept entirely. Mr. Burton points out that it is manifestly unjust that use of this bogus syndrome has been instrumental in his case, the primary vehicle and the only methodology to justify the loss of custody and a severe limitation of his petitioner's rights. PAS is touted to be an accepted psychological syndrome when in fact it has no scientific foundation and has been routinely rejected by courts and mental health professionals as admissible in the courtroom. Nonetheless, PAS is still being used by unscrupulous attorneys and hired gun experts to attack the credibility of parents, usually mothers, and undermine the testimony of little children who have accused their fathers of acts of abuse. It is evident that PAS has been relied upon in Mr. Burton's case, and it was incumbent upon the respondent and his counsel to investigate the validity of their allegations. The use of PAS in this case as a sword and a shield is reprehensible. In Mr. Burton's case, the respondent used this theory to defend himself and simultaneously attack his ex-wife as an alienator, rather than examining his own behavior to determine why his children said certain things. Mr. Burton pointed out that the respondent and his attorney should be sanctioned for bringing bad faith allegations and for basing their case on this junk science. At a minimum, every reference to alienation or parental alienation should be supported by adequate scholarship and scientific research. Any unsupported references should be stricken from the record and kept from the jury in that matter. In summary, as of Wednesday, August 17, 2011, it has been 96 days that the child was taken in a drastic reversal of custody. It's been 41 days since this child has seen his mother, who was the primary caregiver until May 11, 2011. As of Wednesday, August 17, 2011, the child has not had the first minute of summer playtime with his friends or any of the healing opportunities that playtime gives him. The current plan is for the child's education to continue to be compromised. The reversal of custody involved him being taken out of one of the best schools in the state and put in a Title I school that is under an accreditation warning. CPS would turn this train wreck into a cafe, but Mom's question is, how can we get it back on track and somehow headed toward the best interest of the child?